All right, welcome back. I'm with my friend Tom Manzo. He's the founder of CABIA, that's the California Business and Industrial Alliance. We're here to talk about a big win in the Supreme Court for your organization and for Viking River Cruises. Before we get into that, Tom, maybe just tell us a little bit about your organization and then just segue immediately into the Viking Rivers cases, if you don't mind.
Okay, great. Well, first off, Will, thank you so much for having me on your show. Greatly appreciated. The California Business and Industrial Alliance was started in late 2017. The company that I was running was affected by a PAGA lawsuit, wage and hour. Late lunches cost the company about $1 million. Frustration level was high. We reached out to a lot of legislators, a lot of trade associations, and it really seemed like no one wanted to move the needle on this issue and this problem.
Let's pause right there then and just dig into was you mentioned late lunches at your former company. So let's start there. You're running a company in 2017, I guess, and all of a sudden you get hit with what, a complaint of some sort?
Yes, it was an employee, a disgruntled employee who was suing us on a workers' compensation claim. And the workers' compensation claim wasn't going well for her. And then she got referred to another attorney. And the attorney looked at all of our information. They accused us of like 13 different items. And the bottom line is we had a flexible work schedule. So we had people that came in at 5, 5:30, 6, 6:30, but everybody wanted to eat lunch together. So everybody took lunch at 11. And then it actually got moved to 11:10 because the lunch truck couldn't get there at 11 anymore. And we ended up having people that were taking lunches, 10 minutes past 5 hours, 40 minutes past 5 hours, an hour and 10 minutes past 5 hours. Nobody ever complained, but it cost the company $1 million.
And so you get this complaint and it's filed under PAGA, which is the acronym for Private Attorneys General Act. Maybe you can tell us a little bit about the law that allowed this thing to happen and what it specifically empowers an employee to do in this situation.
Yeah, I didn't even know what PAGA was back then. And I was shocked because the frustrating issue was, we had an HR consultant. We had a law firm that helped us on a regular basis with things. And nobody ever sat down and said, hey, Tom, if you take a lunch past 5 hours, you could end up with this gigantic problem. So there was a lot of frustration there. But, what PAGA does, it's a law that was created by Gray Davis and Joe Dunn, in my opinion, both crooks. They both have bad track records when it comes to legal issues.
And just so our listeners know, Gray Davis, of course, is the governor of California at the time. Joe Dunn is a state senator, I think, at that time from Orange
Correct.
County, and and a very big deal in the state Senate at that time.
Correct. So they give this gift to the trial lawyers, and what it really allows someone to do is it allows, the private citizen to step into the AG's shoes. So now I go and I complain, I'm getting a late lunch. They notify the state, and the state has 60 days to respond, which they never do. And after 60 days, I'm the attorney general, and I can demand all of the files, all the employee records. I can demand everything. And the one disgruntled employee for the late lunch now represents all of the employees, whether those employees want to be represented or not. So these turn into class action lawsuits. That's the biggest issue.
Yes. Okay. So I think the key here, it looks like, maybe you can talk then. So you start the organization and you start looking for ways to reform this Private Attorney General's Act. That's the origin of CABIA. And then the Viking River Cruise case comes along. Now, Viking River Cruises is a...
Right. And they're based in Woodland Hills, so California-based company. And Viking River Cruise, I give them just unbelievable amount of credit. They had an employee, they had an arbitration agreement, and PAGA could not be in an arbitration agreement, and the California Supreme Court made this ruling back in 2014, and that's when a lot of these lawsuits exploded. So again, what happens is if you have the one employee complaining, if they can go to arbitration, it's between the one employee and the company. Now that PAGA is involved and you can't have PAGA in arbitration, it becomes between the all of the employees. So the great news about Viking is they decided to fight, and they took it the distance. They took it all the way to the California Supreme Court. And we were involved. We wrote an amicus brief. We spoke with their legal counsel. There's an attorney that was so bold about all the wonderful things he was doing. He drove around a white Rolls Royce with license plates that said Mr. PAGA. He's one of the top 5 PAGA attorneys. He's sued more companies than most. And he was cited in this particular case. The U.S. Supreme Court got a chance to look at, hey, who's Mr. PAGA and what's happening out here? We did a very thorough study that was also introduced into this. And our trade organization, the only group, we took a group of business owners and we traveled to Washington, D.C., and we held a rally in front of the Supreme Court steps. We wanted people to be aware of the situation, and we wanted to generate and rally as much support as we could for this monumental case.
So the interesting feature in PAGA, and especially its, let's call it its enhancement on steroids in 2014, is that it creates this massive incentive for big law firms to step in and take a case that really involves the complaints of a single individual in the workplace and transform it into a class action lawsuit purporting to represent every employee who may work for a company. So there's big dollars at stake. And suddenly, right, it goes from one employee who's complaining about a late lunch to everybody who might have ever had a late lunch. And this would seem to enhance the potential rewards, as well as the settlement leverage, I would think, for the trial, the law firm. Is that fair?
Yes, it's a tremendous amount of settlement leverage. And I think what a lot of people don't understand, so you have a 1,100-page labor law digest. There's so many laws, rules, and regulations. Most likely, nobody is compliant. So what they can do is they can accuse you of things. They can accuse you of rounding. You could have an error on your pay stub.
Rounding, I'm sorry. What's rounding? I'm sorry.
So, rounding, here's what's wonderful is you have a lot of the large payroll companies will tell you it's legal, you can round. You have the state of California telling you it's legal, you can round. So if I clock in every day at 6:57, it rounds up to 7 o'clock. And if I clock out every day at 3:30, it's 3:30. If I clock out at 3:31, 3:32, it's 3:30. So they accuse you of rounding. You have to go back at least 1 year. PAGA's 1 year. A lot of these cases turn into 4 years because it turns into a class action. PAGAs normally are not by themselves. It's a hybrid. They'll do class action PAGA. PAGA is the keys to opening the store, right? And once they get in and they realize and dig through everything, then a lot of times these turn into 4-year lawsuits. But you have to go back and you have to look at all the employees clocking in and clocking out. And if it's in the favor of the employer by 0.1%, then you own the penalty for that. And it can be really, really costly.
It was in your company's case, $1 million, I think you said.
Right. And that was late lunches. And it was a safety incentive, but the safety incentive didn't make up, that large of a portion of it. When we gave out the safety incentive, we didn't recalculate it into the regular rate of pay. So if someone works overtime, and I'm paying an employee that worked overtime a bonus, hey, I'm happy with everything that you've been doing. You've got to go in there and you've got to recalculate this stuff. Well, there's calculators and things like that available that we've created so people don't get into these traps. And they have what's called an overtime true up. So if somebody works overtime, they get a bonus. A lot of times the $100 might not be enough. That you might owe another $5, $7, $10. Sometimes it's more, $20 or $30. So a lot of employers are not going to get these things right. It's commission agreements. They've got to be properly written down. People have to be properly classified, inside salespeople, outside salespeople. I had a call from a member that got hit with a lawsuit. They thought they were all compliant. They thought everything was correct. They had a gift basket that they give away to new employees. Welcome to our company. We appreciate everything you do. They got some t-shirts, some water jugs, and they had $1 scratch-off ticket. In the complaint, they are accusing the employer of giving coupons, gift cards in lieu of wages. So now this employer, even if they're right, which maybe they're not, they're going to have to defend themselves.
Yeah.
They're going to have to spend hundreds of thousands of dollars because they decided to do something nice. And that's why this law is so wrong. That's why it's so severely abused. And in a lot of these situations, a lot of these are lawyer-generated issues. I mean, an employee walks in and says, hey, I just got terminated from my job. That attorney's going to say, well, let me see your paycheck stub. Were you getting your lunches on time? Were they reimbursing you for your cell phone?
Were they rounding your time? Anything. You
got it.
Okay, so they go on a treasure hunt at that point. They're searching for everything they can find and complain about, and then I imagine there's discovery, during which they're going to discover something else that you're guilty of violating in that massive, sprawling labor code, and throw the book at you, basically. But I've in taking you into the weeds here, I have done our listeners a grave disservice. We're really here to talk about the fact that the Supreme Court said, in those situations where a California company like Viking River Cruises has actually signed arbitration agreements with its employee, the Supreme Court decided 8-1 with Justice Thomas dissenting. And we'll get to his dissent in a moment because I think it's fascinating.
Agreed.
The Supreme Court said, no, the state cannot step in and violate a federal guarantee of arbitration. Where arbitration is agreed to by the parties, by the employer and the employee, the state of California can't come in and say, no, mediation doesn't matter, arbitration doesn't matter. All that matters here is that we've got the Private Attorney General's Act, and that's out the window. This person can now file a suit in violation of that arbitration agreement or that mediation agreement, and can represent all other employees as quote unquote plaintiffs in a complaint they never filed. So let's talk about the decision yesterday, because as I say, it was 8-1. That includes everybody but Clarence Thomas. And I think Thomas's logic here, he would have made it 9-0. I mean, a rare show of unanimity in a court that is not known generally for this kind of uniform opinion. Clarence Thomas, if I read him correctly, seems to say only that he really believes that state courts are protected. I think he doesn't say this, but probably by, states' rights. His dissent is a single simple paragraph, and it begins, I continue to adhere to the view that the Federal Arbitration Act does not apply to proceedings in state courts. He seems to be taking a very states' rights kind of position here. Is that right?
Yeah, it seems like he's hung up on some law, I think, from like 1910 or something like that.
And I'm not a constitutional lawyer, but he could just be arguing like this is the 10th Amendment. And, labor law is not necessarily the playground of the federal government. It ought to be up to the states. It's a very strict reading, which I think liberals might in this situation applaud and say, yay, California can be as crazy as it wants to be. The federal government can't intervene on PAGA. But then they'll turn around, and because he is so remarkably consistent, Clarence Thomas is, they're going to say, whoa, on Roe v. Wade, where he wants to throw, abortion rights back to the states, they're saying that's outrageous. You can't have that. So there's no real principle here, I would argue, on their part.
No, but I do find Thomas's decision somewhat disappointing. I just really think California has a tendency to kind of snub their nose at the rest of the United States, and the federal government is here for a reason. There are 49 other states, at least that I'm aware of. So why do we always think California can do things so much differently? I think what's really interesting is, like you said, the 8-1 ruling. Because on the 8-1 ruling, you've got progressives and liberals saying, "Hey, wait a minute, California, you've went too far. This you have to follow the federal guidelines on this."
Well, let me read from the LA Times story. A terrific reporter there who I followed for decades, a guy named Dave Savage. He's the DC-based LA Times Supreme Court and legal affairs reporter. And I think he does a nice job of laying out this particular Supreme Court case, but I'll ask you for your judgment on this. He starts by saying, in a victory for California employers, I have a little problem with that. We'll come to it. The Supreme Court on Wednesday sharply limited a state labor law that has authorized private lawsuits on behalf of groups of workers, even if they had agreed to resolve their disputes through individual arbitration. In the 8-1 decision, the court ruled the Federal Arbitration Act preempts or overrides the state law. California is the only state, he continues, the only state to authorize such private suits as a means of enforcing its labor laws. But in doing so, the state has allowed employees to escape binding arbitration agreements they signed when they were hired, the court said. My only caveat here would be a victory for California employers, which it absolutely is. I mean, this allows business people to try to have relationships with its employees. You've described situations where employers are trying to do the right thing. Your organization was trying to allow flexibility for employees and got pounded for it. You mentioned the gift basket with a $1 scratcher. Hey, welcome to our company. Now sue us under this crazy California law. But I think that it really benefits employees as well, who don't want to be roped into a class action lawsuit that might be devastating to the business, might actually shut it down, ropes them in with an employee who's a complainant that they may have zero interest in siding with. They're loyal to their companies. They like their job. They like their colleagues. This seems to be also a First Amendment issue of freedom of association, that suddenly I am driven by the state of California into a lawsuit I didn't ask for. So I think that it also benefits employees. I think that the narrow focus, and I don't think he had any nefarious intent here, the reporter, David Savage. I think he's just saying that this is a clear victory for employers, but I would add also for employees.
Well, I could tell you this much, and this is something everybody's missing. And I always refer to them as big labor, because labor in the state of California, even though about 15% of the total employees are unionized and about half of those are federal government workers, it seems like big labor, especially the California Labor Federation, is calling all the shots when it comes to legislation. What's even worse is you have a lot of the legislators constantly messaging employers are taking advantage of employees. They continue to take advantage. We need to protect the employees. We need to protect. Well, I got news for you. Newsflash, when it comes to PAGA lawsuits, these employees are being taken advantage of so badly, it's not even funny. They don't know what they're signing. They don't know what they're getting into. A lot of them don't even speak the English. A lot of them don't even end up participating in mediation and things like that. It's almost like they use their name to get this lawsuit started, and that's it. They're done with them. And they promise these employees, oh, we're going to get you tens of thousands of dollars. Very few cases where employees have gotten that much money. Most of these employees that start the thing, end up with $200-300. Sometimes the employees that were all part of this end up with $50, $60, $70. I mean, Uber had a gigantic case, $7.75 million. 3.6 went to the state. $3.6 million went to the state. 2.6 million to the attorneys. $750,000 to the people that wrote the checks. I'm writing the checks for this. I'm getting $750,000. I'd like to find out how I could get that gig. Right?
Become a labor attorney in California.
Right. And the employees got $1.08 each.
Yeah.
How is this any kind of a justice? How are you protecting employees with this law. You're not protecting employees, you're protecting the trial attorneys, period. And again, I say big labor continues to say we have to have PAGA for the non-unionized employers. Well, wait a minute. You've got a PAGA exemption for construction workers. Last year, you carved out a PAGA exemption for janitorial workers. So which one is it? You're definitely, big labor is talking out of both sides of their face, and they have to decide, is PAGA good or is it bad? Because it can't be good for non-unionized employers and bad for unionized employers. Because if you follow what they're saying, you're taking away that worker's rights. Well, what's the difference between an arbitration agreement and a collective bargaining agreement, right? I have a collective bargaining agreement. I have an issue with my employer. I have to sit down individually and get that straightened out. So there's so much hypocrisy going on, and I think a lot of it is improper messaging. And I think a lot of the legislators just don't understand. They're allowing big labor to tell them what to do.
Well, I want to ask you here, there's a couple of people, you reference, big labor, and a lot of our regular listeners will recall Lorena Gonzalez, former assemblywoman from San Diego County, who led the fight on Assembly Bill 5, who told Elon Musk famously when he announced he was moving to Texas, she used an explicit term having to do with intercourse. F yourself. And so, this is.
We ran a full page ad on that, right?
No, tell me. No.
Yeah. So, she did that on a Saturday night. And I figured, maybe she had too much wine with her lady friends, right? So we decided to pounce on that. And we ran a full page ad in the San Diego
Union Tribune. Yeah.
Yeah. And it pretty much said, hey, Elon Musk creates all these jobs. Lorena Gonzalez with AB 5 takes away all these jobs. We showed her her tweet, and at the bottom it said, kind of straightened out a little bit, who's really effing California.
Yes, I love it. I wish I'd seen that. That's a great one.
And we got 5 million impressions on that particular campaign. But I think, again, it goes to the unbelievable lack of respect for entrepreneurs within the state. Whether you like Elon Musk or dislike Elon Musk, what doesn't change is what has he created for California, the United States, globally? I mean, electric car business, SpaceX. Is Lorena Gonzalez launching a Tesla into space and watching it orbit around the Earth right now? No, she does not have the brain power to do something like that. And we had somebody so innovative, so intelligent, created so many jobs, is helping our country's future. And what do? We totally disrespect him. And now, hey, he left the state.
So let's keep the eyeballs
it's crazy.
on. Yeah, it is. And let's keep the eyeballs on Lorena for a second, because she just left. She resigned from the assembly and went immediately to the California Labor Federation, where about now, within the next few weeks, she's supposed to formally, I think, take over the president's job there, the top job. Right. As soon as this Supreme Court decision came down yesterday, I believe you shared with me a tweet earlier of hers. Do you still have that handy? Maybe you can read it to us. Is that
as a matter of fact, I do. So I guess Lorena now is soliciting and lobbying the California legislator. Well, hashtag California legislator. Justice Sotomayor just handed huge PAGA changes to you to modify the scope of statutory standing within state and federal constitutional limits in Viking River. We are here to help. Labor laws must be enforceable, change bad behavior, and seek to make workers whole! ! So first thing I would say is I don't believe she wrote this. She probably had somebody from UC Berkeley. It seems like they have quite a few people that they use on a regular basis for that. But again, I don't understand the logic or the reasoning behind this, because, well, why did they just pass an exemption
Well,
unionized janitorial workers last year when she was in the assembly.
Let me ask you this, though. I'm intrigued by the fact that she's celebrating a Supreme Court decision, which seems to, the Times reporter says is a victory for employers, but she's celebrating it. And then, of course, she has this weird spin on it that it's Justice Sotomayor who sort of led this effort, the decision.
Well, the problem is Justice Sotomayor, she released this opinion at the end of it, almost like she's handing a gift to California. Now, she was the only one that did this, but she is saying, in a way, hey, if you can legislate around this, maybe it's a possibility. So big labor, trial attorneys, legislators, they're all sinking their teeth into this bone, and they're seeing what they can do about it.
Okay,
and
so sorry, go ahead, please.
Well, here's the thing. I think this is going to be a little bit more difficult for them just to go say, hey, we're gonna write legislation around it. Well, good luck. I don't know how constitutional it would be. And I would tell the business community, we should all be prepared, because if they do try to pull a stunt like that, then we should take them to court immediately. People have to quit putting up with these legislators creating these insane laws that make it impossible for employers to survive in the state of California. Otherwise, you're going to continue to see people move out of the state, period.
Let's talk about this California statutes, which are, I think, similar or related to PAGA, but not strictly speaking covered by this Viking Rivers decision. It seems to me that, you and I have talked before, so this isn't a huge shock to you, but, we're very interested also. We talk often on the podcast about Americans with Disability Act violations in California, which are covered by an obscure California variation called the UNRRA Act. And the same mechanism in PAGA is present in ADA complaints in California. So what this means is that if law firms frequently hire people to travel around in a community, like the restaurant district in Walnut Creek or the gas lamp district in San Diego, and they carry a little toolbox with them and they measure the force required to open a door. Does it violate federal and state statutes about how hard it can be to open a door, how wide a bathroom stall is, how high the urinal is, where the mirror and the sink are placed? It gets very, very molecular in that labor code that you described. And the same law allows this, let's call it activist law firm, to then file suit against a mom and pop floral shop, a muffler shop, a dentist's office, a restaurant. Restaurants are very high profile targets, even though they're small businesses. And it allows them to kind of, I'll say it, shake down these small business owners for massive settlements. We went to your location. The letter will typically say to the business owner, we went to your location on June 16th, and we found that multiple violations of ADA compliance, and acting under the Attorney General's authority, we're now suing you, or we're prepared to sue for you, but we could sue you for $100,000. We're settled for 10% of that. And we've discussed stories on this podcast of restaurants simply having to close their doors. They cannot afford to stay open in the face of a $10 or $20 or $50,000 hit. This is not covered by the Viking Rivers decision, but it's a very similar mechanism, isn't it?
No. I could tell you and I'm just trying to do the math right now in my head, because I always tell people, PAGA is like the ADA compliant lawsuit on steroids. So if I were to take what you're saying, which is probably right, a lot of those ADA lawsuits end up settling for like 10 grand. So PAGA lawsuits settle for like 500,000. That's the average. It's 50 times more than what you're paying in the ADA lawsuit. And that's why you see so many attorneys, so many people jumping on this bandwagon, because they see there is so much money that can be made in wage and hour, class action, PAGA lawsuits, period. So it dwarfs dwarfs what's happening in the ADA world. And the ADA world, what's funny is most of the people know these guys are crooks. You read about it all the time. All the same guy sued, 700 different places. The same guy sued, 150 places. Well, they did a Google Maps view and saw that, they only had one handicap space instead of two. It's horrible. It's horrible that these things are allowed. And again, I go back to, it just seems like nobody is protecting the business owners, and not everybody is Apple. Not everybody is Google. Not everybody is Walmart. You're talking about Main Street America. You're talking about people, who maybe, worked 25, 30 years as a police officer, and him and his wife come up with an idea and say, I'm going to open an ice cream store, honey. I've always wanted to have this ice cream store. And they've been in business about 3 years. And then they don't realize that, the restrooms need to be 68 degrees or warmer, or you could end up in a lawsuit. I gave a bonus because somebody was doing such a good job. I ended up in a lawsuit. They decided to work a little bit past 5 hours because they realized we were busy and really wanted to help out, are going to end up with a lawsuit. And this is the shame and the sham of all of it. Because if you truly care about Main Street America, then do something about it. Quit giving the lip service. Quit telling everybody that all business owners are, greedy and out to get their employees. They're out of their mind. Look at right now how hard it is to find employees. Unemployment rate is the lowest it's been. So if I am lucky enough to have enough employees, do you think I'm going to treat them so poorly that they're going to continue to stay? I mean, things have changed. You have social media. You have all of these different things. So if there is a problematic employer, it's much easier to fix than it was in 1930. It's not 1930. If it was up to Lorena Gonzalez and her goons, everything would be back to 1930. I think she wants time clocks. Anybody that's working remotely at home, please install a time clock, because that's what Lorena Gonzalez wants.
So I want to ask you about another related issue that has been in the news that I think is related. Again, it's not covered by the Viking Rivers decision, but so similar. You'll remember that within the last few months, the state of Texas passed Senate Bill 8, which empowered private citizens to act on behalf of the state in order to sue anybody associated with an abortion. It was an attempt quite clearly to cut down on abortions, to in fact eliminate them, by allowing citizens who might be connected with a law firm perhaps to sue anybody. If you drove a pregnant woman to an abortion clinic, if you were the doctor who provided it, if you were somebody who knew but did not stop or somehow assisted in the abortion, you're all liable. And Governor Gavin Newsom, of course, went ballistic and declared this, just an absolute outrage that the state would empower private citizens and private attorneys to go after legitimate abortion providers, how outrageous this is, and said, well, we're going to do the same thing with guns. And I just wonder if it strikes you as if there's anything odd in that declaration that Newsom was shocked by this privatization of the Attorney General's office.
It's just more hypocrisy. And I got news for you. Gavin Newsom's company, Plump Jack Brands, had gotten, sued 3 times under PAGA. So he's dealt with PAGA 3 times. But here's the issue. An elitist like Gavin Newsom, right? We all know he's wealthy. We all know he's connected. He can afford these kind of things. But again, I go back to the small business owner on Main Street, the person that owns the ice cream shop. They can't afford that. They do not have that kind of money. And to be so fixated on Texas, which it seems to be he is, and I think he realizes that he's losing a lot of business to Texas. When Harley Davidson was on the verge of bankruptcy in the 1970s, somebody wrote on the board in the boardroom, the writing is on the wall. We're just all too afraid to read it. And I think the issue with California is the writing is on the wall, but they're too arrogant to read it. Yeah. Because the arrogance that is going on there is unbelievable. I mean, so we're going to do the tit for tat thing. First off, he's surprised about privatized justice. Well, you've already done that. You've done that with the ADA stuff. You've done that with PAGA. So now we're going to say, okay, well, we're going to do the same thing with guns. That's a horrible idea. I mean, the whole thing is a terrible idea. I don't even understand why you're going there, why you're dealing with that. You know, there are so many other irons in the fire, so many other things that need to be done within the state. And that's what your primary focus is on. It's unbelievable.
Tom, we're almost out of time, but I want to ask you one last question. The state of California has said that it had to privatize attorney general's work because there's just so many violations. It had to do this. It doesn't have the staff to enforce the labor code. What's your response to that?
Okay, back in 2004, when they created the law, they had the largest amount of labor enforcement employees that worked for the Labor Department than anywhere else in the United States. And guess what? It has not changed. So we have more people working here. And so that's not true. Again, it's a false narrative. And the other scenario is you have a lot of lawyers creating these lawsuits. How many would you truly have if they weren't out there pushing this? Way, way, way less, guaranteed. If you look at the stats, if you look at the documents, if you look at, you know, what are these lawsuits all about? People would see right through it right away. The problem is the decision makers, the legislators, the people that are in charge putting these laws together don't care. They have their own agenda, and their own agenda is to do whatever big labor tells them to do, because big labor is the ones calling the shots, and they're calling the shots because they're the ones supporting all the candidates, period.
So, Tom, wonderful talking to you again, as always. Where can people find you and your organization if they want to get involved?
Sure. Well, you know, here's one thing that's really important. I'll close with. We really believe in trying to help out the small business community. Okay. And we are putting our money where our mouth is and our knowledge where it should be. If you go to our website, cabia.org, cabia.org, we have in there where somebody can log into arbitration. They can give the information, and within a matter of seconds, they will have an arbitration agreement that they can use between the company and the employees. And we're doing all this no charge. So this is something every employer, I'm compelling every employer in California to do. This will definitely discourage, stop a lot of these drive-by PAGA lawsuits and a way to, really stop some of these. So, if your viewers want, go on there, take advantage of it, get yourself a free arbitration agreement.
Thank you very much, Tom. So that's cabia.org. That's cabia.org. Tom Manzo, thanks so much for making the time today.
Thanks. Have a great day.
Well, that's all the time we have today. You can always find this podcast on the National Review website, but it would be easier for you and better for us if you just subscribe and, of course, rate and review the show wherever you do subscribe. That boosts our profile and helps others find us. And email us with your comments and story suggestions. You'll find our personal email addresses and other fun details in the show notes. And, of course, follow us on Twitter at the Radio Free CA. On behalf of my friend and co-host David Bonson, who could not be here, we give thanks as ever to show producer Sarah Schutte, our engineers Brian Tong and Glenn Hall, and to all of our friends at National Review. Thanks also to Metalachi, the LA-based mariachi and metal band, for our music. La revolución continúa en la semana próxima.